Hello, welcome to week 3 of CJS 251, Introduction to Criminal Court Systems. This week, we'll look at what happens when the defendant in a criminal case has to come into court. First, there'll be an arraignment and maybe a bail hearing, and then eventually the case will move on to possibly a plea bargain or possibly a trial. And most cases are resolved by plea bargains rather than by trials. Trials can be very time-consuming. A jury trial would usually take at least one whole day, sometimes 2 or 3 days, or maybe 2 or 3 weeks or longer. Whereas a hearing on a plea bargain can be done in less time than half an hour, maybe even less time than 15 minutes. So judges very much prefer that cases be resolved by plea bargains. If a defendant takes a case to trial and is found guilty, the defendant is probably going to be getting a harsher sentence than he or she would have gotten if the case had been resolved by a plea bargain. So that gives defendants an incentive to do a plea bargain. But also, since most cases are resolved by plea bargains, when the defendant does plead guilty as part of a plea bargain, the sentence that the defendant receives is really the typical sentence in that court for that particular crime for a person who has a record like the defendant's record. This week we'll be the assignments will include a paper, which will be a comparison of 2 criminal trials. And it would be nice if one of the trials was a murder trial and the other trial was not a murder trial. But please be sure to pick cases that actually are criminal trials. Sometimes students pick a case that's in the news that hasn't actually gone to trial yet, or sometimes students pick a case that was resolved by a plea bargain. But this paper is calling for cases that were resolved by trials. And if you have any questions about the assignment or any questions about the assigned reading, please be sure to let me know. Thank you.